Order was passed. Yesterday was upload. Lordship, order corrected. Respondent number 3 and 4. 5 and 6.
Correction, we'll list it at 2 o'clock. 2 o'clock, नहीं 1 o'clock. Before I rise. इसको for mentioning करके list कराओ. We'll make the appropriate changes and 12 o'clock. 12 o'clock. 12 o'clock. Yes.
Item number 2.
Your
Yes.
Lordship, in this matter, order was passed, Your Lordship, on 16th,
Correct.
wherein the appeal order was set
कर दिया
aside.
मैंने.
But after
All
the
consequential proceedings. Just add the word. यहाँ पे कर दिया मैंने. Is hereby set aside and quashed, as well as all further proceedings thereto.
I'm grateful, Your Lordship.
Though it is assumed that everything falls. Assume that everything is,
Your Lordship,
once the order is quashed, everything is a subsequent proceeding arising out of this order. So everything automatically,
Let's go avoid
Yes.
confusion.
everything arises out of this. This is a recovery process.
The appeal order was the main.
That's what I'm saying. So appeal order, once appeal order goes, every subsequent proceeding automatically goes.
That's.
All right, I'll put that.
I agree.
All further proceedings there too. That's it.
Jumping for a short passover. He's on the leg. He's on.
Next to send.
I know.
5.
5, I am for the respondent, my lord, state respondent.
Yes.
In this matter, Mr. Sunit Rai is the answering respondent, who is for WB CSSC, Central School Service Commission.
Lordship, on the last occasion, direction was given to send the documents on mail ID. Mail ID was supplied on the chat box. And
Yes, there is. Where is Mr. Roy?
This is the evidence of service.
Affidavit of service taken on record. We'll pass it over one time. You're here. We'll pass it over.
My lord, okay, my lord, one indulgence, my lord. I have to, at 11:30, I have to leave, my lord, the town. So if it can be taken.
You're not the answering respondent. It's okay. You can
My lord,
let the pass over.
I'm sorry. 6. Item number 6.
Who's there? Next circuit? Why? After 2 years. Dismissal. Next circuit. At the request of the learned counsel of the petition, let this matter be listed before the next available circuit goes. You are approaching this court after 2 years, sir, the passing of the order.
7.
So, Lordship, I am for the respondent number 5.
On the last occasion, Madam granted me leave to file a petition.
Yes.
Lordship,
Union-
Lordship, am I audible, Lordship? Lordship, am I audible?
Yes.
Lordship, I am representing Union of India, led by learned Deputy Solicitor General.
This is the supplementary affidavit, annexing the extensions and the passport.
You have served a copy?
Okay. Oh,
So,
Yes, Lordship, you have brought.
Supplementary.
Decide the application. Why you are sitting over the application for last 20, when did you make the application?
17 July 2023.
23. You have been sitting over the application.
Lordship, we have to take instruction from the concerned department.
No instruction from the concerned department. 5 times the matter has been listed. Decide the application within 10 days.
I also filed one CAN application. My lord.
They'll decide your application.
Yes, and my lords, in the meantime, my lords, if my lords feel
In
the
the meantime,
mandatory
nothing.
direction cannot be passed, my lords, regarding the extension of visa, at least, my lords, let me be protected from my lords deportation, my lords.
I can't help you. Sorry. That can't be
It is
done.
one judgment, my lords, of the Honorable Delhi High Court. my lords.
Yes. You have not taken any action on the extension of the visa also. Both the applications are pending.
Yes, ma'am. My lords, in this case, my lords, the petitioner was a Indian national and she got married to a Pakistani national and she surrendered her citizenship, my lords, and became Pakistani national. And my lords, when there was ongoing strain in the relationship with her husband in Pakistan, she, my lords, applied for citizenship again, my lords. Now, if my lords would kindly see, my lords, in page 4, paragraph 14, my lords. In view of above discussion, the conviction and sentence ordered to the petitioner is kept in abeyance. The operation of the order directing the authorities to
It's an
deport the
entirely different
petitioner to
fact.
Pakistan. Yes, my lords, the facts are different, my lords. I'm only on the observation, my lords, the issue.
Entirely different facts.
Yes,
Criminal
let the-
matter. it's a
Let the deportation be, my lords, kept in abeyance until my application is decided, my lords.
Not at all.
Until the
They'll
issue-
decide your application in 10 days. Take down.
Lordship, I am appearing in matter number 6, Union of India.
Mr. Mazumdar, you have to decide his application within 10 days.
My lord, since your lordship was hearing my other side, my lord, allows me to file a report.
No, Mr. Mazumdar, there is no time. This is 23 application. The visa is expiring on 3rd of July. If you file your report, the person will be absolutely ineligible for anything. The whole purpose of approaching this court.
Then my lord kindly considers that he has not crossed the 7-year mark.
Whatever it is, you decide his application.
Within 10 days, my lord, 10 days. Anyway, I will communicate and let the ministry take a
Yes,
call.
otherwise, the person is
My
absolutely
job is to intimate them.
left to nowhere. The petitioner.
My lord, he should have come earlier.
3 times so, Mr. Mazumdar, you have taken time. The petition has been pending for the last 2 weeks in my court. One reason or the other.
Yes, my lord. Because of his fault, he could not bring the proper party at the proper time.
Take down. The application has been filed before the Ministry of Home Affairs. Who will decide the application?
Respond number 1.
Mr. Mazumdar, who will decide the application?
Respondent number 1.
All right.
Respondent number 6, Lordship. Newly added.
Respond number 1.
Newly added.
Respondent number
Mr. Mazumdar, who will decide the application?
My lord, the Ministry of External Affairs.
The application is filed before the MHA.
Yes.
Yes, my lord. 6.
So it will be decided by one, respondent number 1. How can you say it will be decided by respondent number 6?
Respondent number 1 is my lord. Just let me check.
Just check it.
Respondent number 1 is Ministry of Home Affairs and let
That
it be
is where the
Ministry of Home
application-
Affairs. No, my lord, respondent number 1, Union of India will do nothing. The Secretary Ministry of Home Affairs will do. Let a direction be upon the Secretary Ministry of Home Affairs. Because the Union of India is just a nomenclature, my lord.
Mr. Mazumdar, please see the application.
To the Secretary, my lord.
The application is filed before the Ministry of Home Affairs.
Yes, my lord. Secretary will decide it.
Secretary of Home Affairs,
Yes, my lord.
not
My
Secretary
lord,
of.
let it open. Appropriate authority, Ministry of Home Affairs will decide.
The
Let us not
petitioner
go into the
has
niceties.
preferred the
My lords, one
present.
indulgence, my lords. I have also, my lords, raised a representation for extension of visa. Let that also be considered, my lords, whether in the affirmative or whether it be rejected, my lords.
This will decide.
Before the
everything.
FRO, my lords.
The petitioner has preferred the present writ petition seeking direction to the respondent authorities to expeditiously dispose of her application under Section 5 of the Citizenship Act 1955.
My lord, one thing, if I may, my lord, I did not find any application before the Home Affairs. Only one, that was on 3rd of July, 3rd of March. He has always approached Malaguri.
I'm sorry?
My lord, only one application was addressed to the Home Affairs. Rest all applications are, my lord, to the FOFO
If I may clarify, my lords, that
or whatever the name is.
for
Anyway, my lord, let the Home Affairs take a call.
क्या लिखा है?
With reference to the file number, my lord.
As an
They have
interim,
mentioned a file number.
क्या लिखा है? Application under Section 5 of the Citizenship Act 19, and also to consider his visa extension application dated 8/5/2025.
2025.
2025. Yes. Full stop. Petitioner is a Bangladeshi Hindu woman who was married to respondent number 5. 5, an Indian citizen on 21/9/2015 in consonance with the Hindu rights
Actually,
and
my lord, it is the mischief of respondent number 5 which has put the lady into such predicament.
yes, whatever it is,
Because the NOC is needed from the husband, that's all.
rights and customs, full stop. Since her marriage, she has been residing in India on a X1 visa, which has been periodically extended, full stop. Learned counsel for the petitioner has filed an additional supplementary affidavit indicating, putting on record the extensions which have been periodically extended to her, full stop. It is the petitioner states that she was subjected to cruelty and continuous. Petitioner states that she had filed an application under the citizenship under Section 5(1)(c) of the Citizenship Act 1955 on 17/7/2023, the petitioner's application is still pending consideration before the concerned authorities, full stop. Then Kallo, the petitioner was subjected to cruelty and continuous dowry demand by her husband and his family, full stop. Initially, she sought financial support from her parents, but due to persistent demands and ill treatment, her family eventually severed all ties from her, full stop. Full stop. Given her X1 status, visa status, she is not permitted to engage in employment in India, making her survival extremely difficult, full stop. Due to the severe cruelty inflicted upon her, the petitioner lodged a complaint with the Siliguri police station, pursuant to which FIR number 30 of 2025 was registered. She has also initiated proceedings under the Protection of Women from Domestic Violence Act 2005, which is pending as a miscellaneous case number 91 of 2025 before the judicial magistrate, second court, Siliguri, full stop. The petitioner's current visa is is set to expire on 3/7, right?
3/7.
3/7/2025. Full stop. Given the estranged relationship with her husband, comma, he is unwilling to provide the necessary sponsorship affidavit for visa renewal. Full stop. Her parents have also disowned her, comma, and she has no other familiar support or place to go. Since her marriage, comma, she has been continuously residing in India and has duly applied for the Indian citizenship. Full stop. In these circumstances, it is observed that the petitioner's application was filed on 17/7/2023, and till date, the respondent authorities have failed to consider her application. Even her visa extension request dated 8/5/2025 has not been answered. Full stop. In view of such factual background, this court directs the respondent authorities to decide petitioner's citizenship application dated 17/7/2023, which has been pending for more than 2 years, within a period of 10 days will suffice. Within a period of 10 days
Madam, you mentioned respondent number 1.
from today.
particularly respondent.
Respond number 1, authority, bracket पे कर देना, authority, don't put it on respond number 1. Let it be respondent authority. If you make the kind
My lord, I also suggest, my lord, because
respondent
respondent number 1 is a vague term, my lord.
then they will say,
My lord, it will be passed around, my lord, among the respondents.
well, then what will they say is, if I have no difficulty, I'll direct respond number 1.
Regarding the visa, respondent number 2, my lord. And regarding the application for citizenship, respondent number 1.
As you mentioned,
Respondent number 1.
respond number 1. Respond number 1 first, and क्या लिखा है? To decide petitioner's application dated 17/7/2023, 2 years, within a period of 10 years. The respondent number 2 shall also take a conscious decision on her application for visa extension dated 8/3/2025 within the same time period of 10 days. Full stop. Both the orders shall be
Representation is
duly
8/5, 2025.
8/5/2025. Both the decisions shall be duly communicated to the petitioner within 2 days thereafter. Full stop. With the above direction, the presented petition is disposed of.
I'm grateful.
If only I may. Lordship, if I may only point out one thing, my lord, the petitioner came up before the respondents only on 1/3/2025. Others were addressed to the local authorities.
That's all right, Mr. What do you want? Decide her
My lord,
application.
the application be
That's
dated
hard.
1/3/2025.
Sorry,
1/3/2025. That was the application addressed to the Secretary, Ministry of Home Affairs.
That's all right. He had made an application. This could have been forwarded to the secretary. Mr. Mazumdar, these are not those cases where you should contest like this.
No, but I'm not contesting. I just want the date to come in. That's all.
Visa application dated 17/7, as well as a follow-up of the same by a letter dated 1/3/2025 to the Secretary, Ministry of Home Affairs.
Well, now, my lord, this will enable me to pin down the ministry.
All right.
Grateful, my lord.
10 days from today.
Lordship, I leave my name
10
in the
days from
chat
today,
box.
Mr. 10 days from today. Please communicate.
Lordship,
I'm grateful.
Lordship,
Lordship, I
Lordship, I leave my name in the chat box.
Take down his appearance. Taptak Sarkar, TGC, appearing for Union of India along with Mr. Mazumdar. Yes.
May I make one prayer, my lord? My lord, am I audible?
Yes, Mr. Mazumdar.
My lord, a humble request, my lord, if your lordship's court officer can give a printout of this order in earlier than usual, then I can mail it within the course of the day. my lord.
Immediately, I will get the order signed immediately. Saurabh,
Because, my lord, I cannot say a lot of things online.
I'll get it immediately.
I cannot, my lord, I cannot submit everything online, but let her stay back.
Yeah, let her stay back. Exactly. That's my point.
But I cannot admit that, my lord.
Yes. So please help her out. Where will she go?
My lord, let the order sheet come out. I will immediately mail it to the ministry.
Immediately. I'll get that signed. The order there, man. Yes.
My lord, in item number 8,
Grateful, Lordship.
I am on behalf of the respondents, my lord. My lord, they have made the Deputy Commissioner of State Tax Jalpaiguri charge as a party to this case, my lord, whereas this is a case of State GST Kuch Bihar charge, my lord.
All right. Mr. Lakotia seeks liberty to amend the cost title. Full stop. Let this matter be listed before.
Great.
Let the same be done. Let this matter be listed before the next available circuit bench. Miss Sarkar always comes up with. Who's appearing in 3 and 4? You are appearing, Mr.
For the state.
Miss number 6 is already over. 3 and 4.
3 and 4.
Mr. Modi is now.
Mr.
8 and
has
9.
to catch a flight.
I'm getting late for 5 minutes, my lord.
My lord, I am for the petitioner, serial number 9, my lord.
Mr. Rai, just wait. I'll just run through it. It's
Serial number 9, I am for the petitioner, my lord.
9.
9, I am petitioner, my lord.
Item 9, yes.
My lord, I am for the petitioner, my lord. But my junior is there, my lord, handed over the affidavit of service, my lord.
You were supposed to take instruction.
My lord, kindly consider my petition, my lord. My lord, my petition.
Sir, before you start, what did I ask you to take instruction upon?
Yes, my lord.
An order which has been passed. You said you have not been communicated with the order. You will give them a new time schedule.
Right, my lord. I have not till today not communicated the order of rejection. My time.
Sir, I have already given you the order last time.
No, that is not the rejection order, my lord. That is the report of the state, my lord. That is not the rejection order, my lord. In that report, my lord, I am praying for leave to file exception to this report, my lord. So many anomalies and my lord discrepancies in this report, my lord, occurred. That should be open in the before the honorable court, my lord. That's why I am praying for leave to file exception to this report, my lord.
Look, who's appearing?
Yes,
Yes, yes.
Paragraph number 6.
Sarah?
Paragraph number 6 of the report.
Yes. Mr. Das, you have to submit a fresh timetable.
My lord, without
Let them.
my lord,
It's okay.
my lord, exception, my lord, allow me to accept.
Learned counsel for the petitioner, learned counsel for the respondent has filed a report indicating that hearing was granted to the petitioner and the timetable
The photo shows 3
and the timetable given by the petitioner was objected to by the other stakeholders. Full stop. In view of the same, the Regional Transport Authority did not issue the timetable in favor of the petitioner and had asked him to submit a alternate timetable, full stop. Learned counsel for the petitioner seeks exception, seeks time to file exception to the said report within a period of 6 and is granted 2 weeks time to file. Let this matter be listed after 4 weeks.
Brief.
Hmm?
Okay.
वो बस I'll just yes.
Lordship, in item number 10, yesterday, Lordship, I have mentioned that the state is not the answering respondent. RMC is the answering respondent, Lordship.
Matapanga.
Yes, Lordship. I already informed learned
Private.
Lordship, I informed learned additional advocate general who used to appear for the RMC Lordship. But copy has not served to RMC Lordship. Yesterday, come to know. Even today also he spoke with me few minutes ago, Lordship. So he requested me kindly fix the matter in next circuit, Lordship.
No, but you will execute the notices you have issued. It's a completely wrong reliance of the judgment.
Yes.
Lordship, without heard the RMC Lordship.
No, madam, then they will go ahead with the notice.
Lordship, I also go through the record, Lordship. I saw
No,
the
but then
matter.
you will go
Yes.
ahead with the notice. If you
Yes,
see the
Lordship.
notice, then the whole purpose is defeated. See the notice which you have issued to him.
Yes. Lordship, then kindly fix the matter 2 p.m. Lordship. By this time, I will contact with him. Because he is traveling, Lordship. Minutes ago, I spoke with him. He is in.
Respondents.
I have
If your lordship kindly come to the order passed by this honorable court, page 31, on the basis of the order passed my writ application, the allotment was made to me.
It is not made to you, Mr. Mathi. Show me the order.
Page 31, if your lordship kindly
Yes,
come.
page 31.
Yes.
Yes, that is your submission. See the operative portion.
Kindly see. Operative
That is
portion.
your
kindly see
submission
over
that I was allotted D4. That is your
Yes.
submission, not your
Yes.
allotment.
Yes,
Now
that
see
was.
Mr. Mathi, please see the observation on page 51.
Yes, my lord. Kindly see, my lord, paragraph 19. On the basis of the note sheet. Note
Mr.
sheet
Mathi,
takes a-
please see paragraph 31 and 32.
My lord, paragraph 31, 32 refers to the note sheet. Now, note sheet has been is not annexed in the writ application. Paragraph 19 of the judgment, if your lordship kindly see.
Mr. Mathi, please see para 32.
Well, I have seen, my lord, para 32, my lord, refers to the,
Yes.
my lord, note sheet. Then, my lord, kindly come, my lord, paragraph 33. Paragraph 33, kindly see.
I have seen it.
Paragraph
seen it.
33.
I have seen it. I have seen it.
Respondent shall same writing and it may be communicated to
The
him.
petitioner has been, sir. The respondents, I can't take it at 2 o'clock. Today, I can't take it at 2.
Yes.
Take down. The petitioner in the presented petition, comma, challenges the notice dated 13/5/2025 and 12/6/2025. The paragraph 32 is itself clear that if there are no plots, they will allot you anywhere, not even in this complex, anywhere in the market.
My lord, if you lordship kindly come, my lord,
Anyway.
my lord, page 30, my lord. My lord, page 30, kindly come, page 30, my lord. What is his representation to the authority? Page 30. He is
Oh.
asking the another plot.
Poor people. Anyway, the petition, the petitioner, comma, in the presented petition, comma, challenges the notice dated 13/5/2025 and 12/6/2025 issued by respondent number 5, comma, whereby the said respondent, bracket में डाल देना, कूच बिहार जिला regulated market committee, bracket close, comma, whereby the said respondent has allegedly and illegally allotted the petitioners stall number 4 to respond number 8, full stop. The case of the petitioner is that he has been running a shop at Matabanga Market, full stop. Subsequently, the Matabanga Regulated Market Committee decided to construct a new market complex, pursuant to which the petitioner temporarily vacated the premises, full stop. Upon completion of the market complex, the petitioner paid a sum of rupees 1.34 lakhs towards part salami. Bracket में डाल देना, out of total salami of rupees 2.20 lakhs. 1.3 bus 1. Towards part salami on 10/11/2003, full stop, bracket छोड़ दो. Thereafter, the keys of stall number 4 were handed over to him, and he has since been occupying the said stall, conducting his business therein, full stop. The said stall was mutated. It was mutation also, mutated in petitioner's name, and the electricity connection was also issued in his name. Stop. The Matabanga municipality further issued a permanent certificate of enlistment in favor of the petitioner, full stop. Thus, he has been continuously carrying on business from stall number D4 since 2003. Full stop. D4. On 7/4/2025, the Secretary Marketing Committee informed the petitioner that respond number 8 had filed writ petition number 16803/2003, and that by order dated 13/3/2025, this court had allegedly directed the marketing committee to allot stall number D4 to respond number 8. Under pressure and without perusing the order of this honorable court, the petitioner submitted a letter dated 7/4/2025 to the marketing committee requesting alternative allotment of stalls at E2, E4 and E6, full stop. Subsequently, upon obtaining and reviewing the court's order dated 13/3/2025 through his advocate, the petitioner discovered that no such direction had in fact been passed, full stop. Accordingly, the petitioner withdrew his earlier letter dated 7/4/2025 by submitting a. When did you withdraw it?
No, I said, I'm not giving.
All right.
I said, no,
No, नहीं वो छोड़ दो फिर. Discovered that no such direction has been passed. Full stop. No such direction has been passed. However, while impugn notice dated 13/5/2025, the respond number 5 pasted a notice on the stall on the wall of the stall D4, indicating that the same has been allotted to respond number 8 pursuant to this court's alleged direction in WPA number so and so dated 13/3/2025, full stop, and warned that any person occupying the stall would be evicted, full stop. Despite being fully aware that the petitioner has been in lawful possession of the said stall pursuant to payment of part salami and mutation in his name, respond number 5 acted in disregard of facts to favor respond number 8, full stop. Aggrieved by such arbitrary and illegal action, and apprehending eviction, the petitioner has filed the present writ petition seeking appropriate relief, full stop. Learned counsel for the respondent prays for and is granted 4 weeks time to file the affidavit in opposition. The petitioner is permitted to file a reply thereto within 2 weeks thereafter, full stop. From the documents on record, including the certificate of enlistment and electricity bill, and the fact that the stall has been mutated in favor of the petitioner, it is evident that the petitioner has been in continuous possession of stall number D4 for a significant period, full stop. The stall, the petitioner, the petitioner has already paid the part salami in favor of the allotment of the stall, full stop. A perusal of the order dated 13/3/2025 passed in WPA number 16803 of 2003 reveals that no direction was issued to allot stall number D4 to respond number 8. In view of the above, this court is of the prima facie view that the petitioner is entitled to retain possession of the stall number D4, full stop. Accordingly, the respondents are restrained from taking any coercive action or steps to evict the petitioner from stall number D4 for a period of 10 weeks. In the meantime, the respondents may explore the possibility of allotting an alternate stall to respondent number 8 in terms of the order passed in WPA number so and so.
My lord, may I submit one thing, my lord? If you also kindly see, my lord, the paragraph 31, it is specifically mentioned, my lord.
For a period of 10 days, nothing else. Don't
No,
try.
it is already there in the order, my lord. If you also kindly see paragraph 31.
Sir, challenge the order.
No, kindly, my lord, it is already there in the order, my lord.
Mr. Matthew, challenge the order. I have read the order. 10 weeks. 10 weeks.
10 weeks.
कौन सा बताओ. Yeah. 10 weeks or until further order. Bus. Four weeks, 6 weeks, 8 weeks.
11 I appear for the petitioner.
Yes.
My lord, I have not been able to serve this state because there is an urgent need for the injunctive relief. I am waiting for an
Dr.
injunction.
Arjun.
Lord, let me place the law, my lord.
Oh, if you have not served the state, you have to serve.
Lord, Rule 26 has been period for that issue. That
Serve the
notice
state,
is-
sir.
In the meantime, let there be a stay on the notices, my lord. That much. My lord.
No.
Notices have been, my lord, issued to me,
Let
not
it
following
pass.
the law.
Dr. Arjun not here. Not without service. Next, sir.
Lord, let there be a direction for serving them.
I want.
My lordship, copies are not served yet. Please.
Same order.
Lordship, 14 is safe.
Same order. 13 is same.
13 and 14 safe. 12 and 13. sorry.
12 and 13 same.
14, my lord, returnable date is given the 30th in the notice.
36.
What mistake?
Next, sir.
Have the request. Next, sir. ये खत्म कर दो. ये तमाम ये सारे FMAT हैं. There is a delay of 182 days.
Lordship. So I have already filed the CAN application, Lordship. Let there be a direction to start the copy of the respondent, Lordship.
What a defect.
I have one uniform where, Lordship.
There's a delay here. 182 days of delay. नहीं delay control नहीं करेंगे. Notice only on the application.
Lordship,
There's a CAN application for delay.
Lordship.
Just notice on the.
Sir, one submission, Lordship. Service upon the respondent number 2 may be dispensed with, Lordship. Since they have
Not at this stage.
Since they have not contested.
I know, not at this stage.
Lordship.
CAN has been filed with a delay of so and so. Let the notice be issued. on the canopy.
Lordship, I am
Same order. All with a delay, 950 days. Delay of?
Lordship,
Delay of
950 days, Lordship.
950. Sub delay.
Lordship.
Yeah. The certified copy of the judgment is derived of the list of dates for calculation of the limitation. Thus, a certified copy of the impugned judgment may be sent down to the trial court for necessary correction. Report on limitation being furnished on receipt of the corrected. There's a defect here. Remove the defect. Defect to be removed.
Lordship, I am appearing on the judgment, Lordship. Same direction we pass, Lordship. There is no defect, Lordship. Direction to solve the copy.
Delay. इसमें वो फर्स्ट वाला जो ऑर्डर है नोटिस नोटिस ऑन द कैन एप्लीकेशन
Lordship.
You have to file a condemnation of delay application in 18.
Lordship, 18 actually is appearing, Lordship.
There's a delay of 32 days. No can application. You have to file a can application, sir.
Lordship, I will check. Appeal has been filed by the insurance company.
I will check. I will check. I will check.
I am the
Check it.
respondent here, Lordship.
Defect to be removed.
Yes.
Statutory amount is also not paid,
No, it is paid.
not reflected here. Just check it, defect to be removed. File a can application.
Yes. देखो. एक तो report पे था.
Defect to be removed. इसमें भी defect है. Defect to be removed, 19. Who's appearing in 19?
Lordship, Mr. Pashupatinath is appearing.
None for the petitioner. Let this matter be listed before the next available circuit bench. None for the parties.
1927.
None for the parties.
No.
Next circuit. Yes. Same. No password. How many passwords? Three.
Because if I don't ready, then I make it very short.
No, but why are you even trying your?
Because the excess of I just, and I brought the judgment, I rely on your lordship judgment, I brought them. You can see, you can come to face 31 first,
31.
make it short.
Page 31,
This is my invoice.
your invoice.
And there's no discrepancies. Can you see? Say that 350 bags and neighbor is 24,500 bags. Kgs 141.
Yes.
I think the cost weight is 24850 because per bag is 1 kg 350 plus. So I think the cost weight of 24850. I give the names of my lord, concerning area, everything. There's no difference. Now you can come to my email, that is 33. There's no discrepancy. Those are automated one. Now they have intercepted and come to the order at date 34 months. This is the verification report. What they have said, they have said they have taken the gross weight of the goods and the vehicle on the visa OMN slip, which is not a statutorily prescribed document. And the unladen weight of the vehicle. So it amounts to according to that, the net weight of the goods is 420 kg bag. 420 kg is excess. They have not taken the weight of the 350 of concession of 350 bag weights. So even 420 bags. My lord, you can see tax liability is only 3,000 rupees.
Yes.
But my humble submission, my lord, so if according to here are according to they have my rate is 145. They have given us 240 rupees. Given us 240 rupees, if it comes to 5%, is my lot. It's my 5,040 rupees. According to our rate 145, it comes to my lot only 3,445. If it is a less of the my cost, my bags are then it come on my 5,500 rupees. So now I am coming on the section 126. My lord, they have followed the order, the input order of the same thing they have followed. They have taken a new points that regarding concern in particular, those are not in the show cause notice. They have taken it. The input order is at page, my lord, 55. Start of 54, they have taken at this point that regarding this 420 kgs is excess goods. Well, there's no, they have not made out any case that I have an intention or means here to evade tax money. Even it is my 420 bags, this is only within the 5,000 rupees. Why not? You also consider that I place a judgment there, so I say it is in the extra jurisdiction. I place and whether I left your Austrian. You will can come to internal affair running this please. Running this please, my lord.
Yes.
This court has heard the argument advanced by both the parties and has gone to the document produced to be principal principle law that in order to invoke personal the intention to evade tax is mandatory. This was just my lord. Next judgment can come to case in running this 3-7 my lord or division judgment start based running this 5 and come to my lord running this 7 or division judgment.
Page 7.
Therefore, the question I invoked to on act not arrive. The fact in our case is that apart the authority has not been able to pinpoint to show that applicant had an intention to evade payment of tax. The more coercive principles are identical and is not being disputed by the department. This is our division of Chief Justice judgment. Then you also carry judgment next judgment at the running page at 24. Same minus Gujarat High Court says.
Only give me a copy.
Yeah. 39. It starts from it starts from page 9. My lord, the big judgment was I grab the paragraph 39 and page 22 and 3. Same thing happened. And now there is very regular judgment, my lord, people of Scandi.
So, Mr. You can go in appeal. What is the difficulty?
My lord, this is extra jurisdiction, my lord.
If you see the judgment which you are relying upon of Justice, Honorable Chief Justice, even there, the appellate authority had already taken a view.
This is what
they are.
This does not make my
Anyway.
I've seen my lord. Your Lordship has given.
What are you sure?
The first judgment, your Lordship has given the read. Second, my lord, second
fact-
judgment of division bench,
Facts
not
are
from the appeal.
Facts are different, Mr.
No, my lord, can you see, even of tax, my lord, there is no 420 rupees, my 420 baggage. Can this, my lord, this is only 5,000 rupees, my lord. Now I am coming, my lord. You can kindly come to on judgment at case 30.
Page 30.
Yes. This is a division bench judgment of it starts with page 29.
Yes.
And can you see that above division bench judgment, my lord. Can you see paragraph 5? Learned from that, we have regard to paragraph 7 of the judgment of single assessment. And to what is argument that unless there is intent to evade tax, no penalty should be imposed under section 120 of the Act, my lord. Now, my lord, very relevant judgment. This is at page, my lord, 34. It starts with 31. The judgment of book. Very befitting here, my lord, and come page 34. Paragraph 8 and 9.
Yes.
Having heard the landed council for petitioner, we find that even the second count is by the to be shut down. From the invoice, it is clear that quantity of consent is shown to be 1 0430 or an amount of rupees 17671 paid as tax on the consignment as per state it was 10520 kilograms. State deposits the weight is less than 1%. As the state, the largest irrigation shall not be more than 11,000. Here are 5,000. Keeping view of the circumstances, it also said the petitioner had any intent to evade the tax or the mismatch the quantities of such nature, which shall entail proceedings under section. The person who had already paid the tax of rupees 12 plus or the consignment of cannot be said to have intent to evade tax of 11,000. And this time, Mr. Gold said that he is ready to pay the tax and of the impost or which comes to rupees. Here, what the same thing happened. There's a account is raised. Coming another 126. Oh, to my lord. My lord, the lordship, I'll show one judgment. This judgment regarding at page 78 point.
Give me a copy so that I can.
I start at page 75. This is division. Here, my lord, 120% is a division. I Supreme says no. To appeal. My lord, I got him showing paragraph 10, my lord. The respondent had a statutory remedy under section 177. Instead of appealing of the remedy, the respondent to the petition under Article 226. The existing alternative remedy is not an actual bar. The main to the deed petition under but a deed petition can be entertained in exceptional circumstances where there is. My case is and I don't change the fundamental rights and excess of jurisdiction. And coming with an excess of jurisdiction, my lord. You also did the same thing, my lord. Past judgment, you lost it say. And you see, you also say that these two fourth London Council petition submit that in view of settled question law, this court is also considered without no special possibility serve delegating the matter to the appellate authority. Yes, see, my lord, you lost also.
Yes.
But this is my lord, what you see.
Shall we
Yeah.
hear it? You're done?
No, I just wrote a section on. Why did you see? Wait. What are you? This first.
GST Act, right?
Section 126.
I.
No officer under this act shall impose any penalty for minor breaches of tax regulations or constitutional requirements and particular any omission or mistake in documentation which is extremely verifiable made out fraudulent in of loss material. For this purpose of this section, a breach shall be considered minor breach if the amount of tax removed is less than 5,000 rupees. Here the same thing, my trouble. Any omission or mistake in documentation shall be considered to be verifiable if the same is an error at the face of the record. And my to sum up my submission. First, my lord, they could have quoted measured the net weight of the goods. They have relied upon a women's slip, which is not the statutory prescribed document. Secondly, my lord, they on the presumption this weight is 420 is much more on the basis of the difference weight of the weight, but this is not prescribed under the CGST anywhere. The rules are in circular. Fourth, my lord, even if it is a 420 is excess, tax liability is less than 5,000, my lord.
Yes.
May I? My lord, first of all, I would like to submit that what my learned senior friend submits that as per section 126, the penalty would be 5,000. Kindly have a look into the section 126 subclause 6. 126 subclause 6. 126 is for minor defect, minor mismatch. And in subclause 6, it is categorically mentioned the provisions of this section shall not apply in such cases where the penalty specified under this act is either a fixed sum or expressed as a fixed percentage. In section 129, there is categorically mentioned that the penalty would be 200%. It is category. That means fixed percentage, fixed sum was mentioned in section 129. So 126 will not be applicable in this case. Second thing, from the page number 56 of the writ petition, Your Honor will find that page number 56,
Yes.
1.2, mention 1.2, 1.3, 1.4, 1.2. What was the mismatch? After interception of the conveyance, the statement of the driver of the conveyance was recorded in form GST move 01 on 16/5/25. The tax invoice, UA bill and consignment note was checked and found that in the UA bill such and such dated 13/5/25, time of issuance of UA bill was before the time of payment of goods in the invoice by the payment slip number such and such, and weight mentioned in the invoice is less than the weight mentioned in the payment slip. Thereafter, 138 prescribed filing, as per section 135, what was the documents are required during the movement of the goods, it is mentioned. Thereafter, this led reasonable belief that the goods in conveyance were transported without proper documents and genuineness of the goods in transit, and tender document required further verification. I would also like to submit section 135 of the GST Act. Section 135. In this reference, section 135, that is culpable mental state. তাই না? দেখো তো।
Presumption of culpability.
Huh? Culpable mental state. Yes. Wait. Presumption of culpable mental state. May I read, my lord? In any prosecution for an offence under this act which requires a culpable mental state on the part of the accused, the court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offence in that prosecution. For the purpose of this section explanation, the expression culpable mental state includes intention, motive, knowledge of a fact, and belief in or reason to believe a fact. A fact is said to be proved only when the court believes it to exist beyond reasonable doubt, and not merely when its existence is established by a preponderance and probability. My humble submission is that the consignor of Assam, he filed in view of someone. So notice was served upon all the person, driver, consignor, consignee. Consignor appeared. He filed a statement. He filed a written objection. Nowhere from the written objection he failed to establish that the women slip which was produced by the driver was mismatched. How it was mismatched, he failed to establish. Probability and liability it is upon him to establish his case, but he failed to establish. From the women's slip which was produced by the driver at the time of interception, there was difference of 440 kg, and from 420 kgs. 420 kg there was difference, and the rate which was mentioned in the invoice, and the rate was different. 140, they have mentioned 140, but 145, but according to on that date rate, it was 240. So all these things, he failed to establish his case. How there was discrepancy, how there was the mismatch. That's why notice was issued, and natural justice was given. Personal hearing was made. After that, final order was passed, and demand notice was issued. Against that demand notice, he has every opportunity to prefer appeal before the appellate authority under section 107 of the CGST Act. And in case of appeal, initially it was 25% of the claim amount. Now it is 10%. And if he succeed in the appeal, in that case the 10% will be refunded to the petitioner. This is the statutory provision. So I think my humble submission is that this writ petition is premature. There is FAQ's alternative remedy before the appellate authority. So this writ petition may kindly be dismissed. That's and with respect to this judgment, no copy has been served to me. But from the hearing of my learned senior, I found that those cases are different with respect to this case. Those judgments are not relevant in this case. That's
My learned first level 126.6. But I just answered it by the judgment of this our Delhi High Court. If you also can come to start on page 9, relevant page at 24 of the judgment. My lord. This is judgment of
judgment copy chhara, how I will answer without the copy?
at least 24 is 45. No, 45. We also find ourselves unable to make section 129 embodying an improvement or restricted either override or completely section 126. Except certain interpretation would clearly among required the benefit of the principles of operation or coordination of section 126 includes an enjoins to the bone in consideration by considering the levy of penalty. Provisions contain subsection 6 up to the 120 also cannot possibly late and putting down the application of subsection 1 and 2 of the 126 it orders it can apply in cases where penalties can specify either as a fixed sum or percentage. This prosecution, this part of the description of a fixed sum or cost of quantification of penalty as we notice about one that allows principal in subsection 1 be 2 as a complaint. We have already found that the consideration which are spoken of in 128 neither is trivial nor rectifiable. Section 126 does offer only so far as the transaction or the limit of the subsection referred as the so my analysis is not correct. On the other provisions of the chapter there from 9 and they use the expression which may extend to shall not exceed. These are instances where the penalty in any case cannot be described fixed sum or one except as a fixed percentage. So here is not a fixed percentage. They said 2000%. Here, my lord, he said according to them, my lord, he has not denied it. The tax level is not more than 5,000. He has not denied it. So, my lord, so the intention tax division is not there. My lord, my humble submission, they can initiate the proceedings under section 129. Primarily, they have to establish that there is the intention of the according to mentor, I have intention to even the tax, my lord. When I paid the huge amount, only 5,000 I have not paid. Secondly, my lord, he has not answered. Is there any procedure laid down to measure the goods in such a manner? He has waiver slip. He has not said whether it's a statutory document or not.
Judgment.
Take down.
My lord, 129, the penalty was amended in the year 2022.
Yes. 21.
So, sorry, 21.
21.
21.
Yes.
And when the judgment was passed, afterwards, but in that case, kindly let me submit. In that case, kindly give a direction to hand over the copy of those judgments so that I can reply.
Nothing is there in the judgment. Hold on. The petitioner has filed the present writ petition challenging the order dated 2/6/2025 passed by the Assistant Commissioner bracket में HAEU bracket close comma CGST and CX comma Siliguri Commissionerate under section 129(3) of the 129(3) of the Central Goods and Services Tax Act 2017, read with corresponding provisions of the State GST Act 2017, comma, the Union Territory GST Act 2017 comma, and the Integrated GST Act 2017. Full stop. The case of the petitioner is that the petition number 1 acting, comma, acting as a consignor, dispatched 350 bags of Assam dried Erica nuts having a net weight of 24,500 kg to the consignee, comma, MS Vamika Traders, comma, situated at Kanpur. Full stop. The goods were transported through a vehicle bearing registration number UP 14H 7566. Belonging to Nagpur, Assam road lines. HT है हाँ? HT 7566. UP 14 HT 7566. HT हाँ, 796. Full stop. The goods were accompanied by all requisite documents, comma, including the e-way bill, comma, e-invoice, comma, and consignment note as mandated under section 138A of the CGST rule, of the rule. Requisite document including e-way under rule 138A of the CGST rules 2017. Full stop. As per the tax invoices, comma, the net weight was mentioned as 24,500 kg, bracket में 350 bags, bracket close, comma, with the gross weight recorded as 24,850 kg.
Those are what bags, man.
Yes. That's what I'm saying. Comma, thereby amounting to a taxable value of 32 lakhs 52,500, attracting a total tax liability of 1,77,625. Full stop. On 16/5/2025, comma, the officers of the headquarters anti-evasion unit, bracket CGST and CX, bracket close, comma, Siliguri Commissionerate, comma, intercepted the said vehicle near Pradeep Hotel, Fulbari, comma, and detained it for physical inspection. Full stop. A weighment report dated 17/5/2025 was prepared indicating that the gross weight of the vehicle along with goods was 36.310 mt, comma, while the unladen, bracket में tear, bracket close, weight of the vehicle was recorded as 11.390 mt. Full stop. Based on this, comma, the net weight of the goods was found to be 26.920 mt, comma, implying that there was an excess of 420 kg. Full stop. Subsequently, a detention order dated 19/5/2025 was passed. Full stop. Thereafter, a notice under section 129(3) was of the CGST Act read with section 20 of the IGST Act 2017 was issued on 26/5/2025 and served upon the petitioner. Full stop. The petitioner submitted a reply dated 27/5/2025. Full stop. The Assistant Commissioner, bracket HAEU, bracket close, CGST and CS, comma, Siliguri Commissionerate, passed the final order dated 2/6/2025, comma, wherein the tax value of the goods was assessed at the rate of rupees 240 per kg, comma, instead of the declared rate at rupees 145 per kg as per the tax invoices. Comma, the petitioner contends that the invoice declared value qualifies as the transaction value. Bracket transaction value कर देना, transaction value, ये bracket में inverted comma कर under section 15 of the CGST Act, comma, and therefore must be accepted unless proven otherwise by the respondent with cogent evidence. Learned counsel for the petitioner has relied on the judgment of
The 6 and 7 say these are
6 and 7.
yes.
Relied on the judgment citation so and so 6 and 7. Citation. Agree by the said order, comma, the petitioner has approached this court by filing the present writ petition. Full stops. It is pertinent to note that the impugn order dated 2/6/2025 is in a learned counsel for the respondent says that the impugn order dated 2/6/2025 is an appealable order under section 107 of the CGST Act. However, the petitioner has not availed the statutory remedy and has directly approached this court and the same shall be dismissed on this very ground. Learned counsel for the petitioner submits that the impugned order suffers from lack of jurisdiction and that insisting on statutory pre-deposits for filing appeal would result in grave injustice, comma, especially when the tax liability has been determined on the basis of unsubstantiated market value rather than the transactional value. Full stop. Learned counsel further argues that the conclusion regarding excess goods bracket 420 kg was arrived at using a weighment slip which does not conform to any statutory procedure under the CGST Act or rules. Let me, Mr. Full stop. It is contended that the respondent ought to have physically weighed the goods in the presence of the driver. Full stop. The reliance in the weighment slip, comma, allegedly not authenticated or accurate, comma, is therefore misplaced. Full stop. Moreover, the market rate of rupees 240 per kg used by the respondent has no legal basis, comma, especially when the transaction value of rupees 145 per kg is duly supported by documentation. Full stop. Learned counsel for the respondent raises a preliminary objection regarding the maintainability of the writ petition.
126.
He further submitted maintainability of the writ petition, comma, asserting that the petitioner has bypassed the statutory appellate remedy, full stop, under section 107 of the CGST Act, full stop. It is further submitted that as per the driver's statement dated 18/5/2025, comma, the transporter mentioned in the documents was Nagpur Assam road lines, comma, while the goods were loaded by Sundra road lines, full stop. The driver expressed ignorance about the consignor and consignee, comma, and the stated transporter, comma, and also noted that the loading point lacked any identification or signage, full stop. The respondent contends that the weighment was conducted in the presence of the driver and two independent witnesses, following the usual administrative practice in such matters, full stop. The valuation of rupees 240 was based on prior similar consignments and prevailing market rates. Full stop. Full stop. There were too many discrepancies, and hence the respondent authorities rightly doubted the genuinity of the transaction and imposed the penalty. Full stop. Further, there is no procedural flaw and violation of natural justice which warrants the interference of this court. The petitioner can always file a statutory appeal and take all his grounds therein. Full stop. This court has carefully considered the submission of.
But this, and you see the if the 420.
Mr.
Tax is more.
Rai, you have made your submission, Mr.
Sorry,
This
tax.
court has
500.
carefully considered the submission of both the sides and has examined the records placed on file. In the present case, the respondent authorities, after detaining the goods in question and conducting a weighment exercise, concluded that there was an excess quantity of 420 kg of Assam dried areca nuts in the consignment over and above what was declared in the tax invoice and accompanying documents. Full stop. The said conclusion was drawn on a weighment slip, which recorded the gross weight of the loaded vehicle as 36.310 MT and the unladen weight as 11.390 MT, thus indicating a net load of 26.920.
No, 24. 24.9.
24.920 MT, full stop. The declared net weight in the document, however, was 24,500 kg, full stop. This court notes that the petitioner has not placed on record any reliable material to dispute the said weighment figures, full stop.
No, I said this is not
Further
document, my lord. Factors are prescribed.
Mr. Rai, you can challenge the order.
No, that I can want to.
Please, Mr. Rai.
No, but I just.
Please, Mr. Rai.
This is my.
I've recorded your submission.
No, this is my first submission to my lord, 420 kgs. His tax is 5,000. So there is no question even intention. This is my
petition का वो लिखा हुआ, उसमें लिखवा देना एक और line. Mr. Rai states that the maximum tax penalty which can be raised on the said evasion will not exceed more than rupees 5,000.
My lord,
Furthermore, Mr. Banik, please.
126 subclause 6, I have submitted already. 126 sub.
I'll take care of it, Mr. Banik. Furthermore, the document submitted by the petitioner, including the invoice, e-way bill, and consignment note, do not disclose the appropriate weight of each bag, which could have served to rebut the respondent's inference of excess quantity. Full stop. The petitioner was granted an opportunity to respond to the notice issued under 129(3), yet no supplementary documents, such as the original purchase invoice from the supplier, weighment certificate issued at the time of loading, or proof of bank transaction showing consideration paid by the consignee, were submitted to support the bona fides of the transaction. Full stop. The bank statement of the petitioner, as examined by the authority, also do not reflect any payment, either in full or part, by the consignee.
I have only paid my funds.
Consignee. MS Vamika Traders. Full stop. These omissions, when
This is only the so-called notice, my lord. You understand this federal law, my lord. Unless it is supposed they can take this one. I bought the judgment, my lord. You also kindly
change. You take that order in appeal, Mr. Rai?
You can relegate this matter, but you also can't.
Why will I relegate the matter, Mr. Rai? You take it in appeal if you think the order is bereft.
No,
Mr. Rai, please do not interfere.
You also can't take note of my judgment, my lord.
All right.
So you also
I'll
can-
pass, dismissed. I'll pass the order in the chair.
My lord, you also can-
Grateful.
you also can appreciate. But our High Court, this is a judgment Supreme Court, my lord. Once
Mr. Rai,
get taken from the air, my lord.
I will
It's not
pass-
a show cause notice.
Dismissed, I'll pass the order in the
This point, my lord, it's not a show cause notice, my lord. You can appreciate.
I will appreciate.
This, my lord,
I'll record that, Mr.
my lord, I just.
I'll record.
Please, I just, I want to.
Mr. Rai, I will record all your submissions.
He what said, it's not a show cause notice. You can go beyond this.
Mr. Rai, dismissed. You cannot tell this court what orders to pass.
No, I.
Mr. Rai,
I know it, my lord.
You are a senior counsel.
I know that I can't say.
yes,
It's the court.
you have
I said,
assisted,
my lord-
you have assisted the court. You are interfering in passing the order. Mr.
No, man, I said, my lord.
You are
It's
interfering.
not my habit, my lord. What I
You
said-
are interfering.
What you said,
Mr. Rai,
it's not a show cause notice.
I'll deal with that.
If it's not a show cause notice,
We have a provision of appeal
that is what, I thought,
against all orders.
you said, my lord, you stand, laugh at me, well, can he takes me to the room. I know it, but my lord, what's my duty to just place your lordship, my lord, what is the point has been taken, it's not a show cause notice.
All right. I'll deal with that, Mr.
Yes. My lord,
Good.
I can't say that you are.
Okay, next time.
Next to the same.
Number four.
My lord, can we
Still.
upload this, then, my lord, so I can take it.
Item 4 also same.
Item 4 also same, my lord.
All right.
Only date and measurement,
Yes, my lord, really.
I'll deal with
Not the,
date and measurement.
you have not do anything.
I'll deal it.
No,
My lord, me is not coming.
I have also. it is
I'll
also-
deal with that.
My lord,
Grateful,
can you-
man.
keep it.
Not today, Mr. You can't dictate the court, Mr. Rai. You as a senior advocate, if somebody would else have done that, I will recorded 4 paragraphs against you.
But I do it. He also
4 paragraphs against you, I would have dictated.
He also knows me.
And I would have advised,
I
Mr.
not do
Rai,
that.
do not push me.
No, my lord.
If you push me, I will also record that you don't deserve many things. Please do not push me, Mr. Rai. You are pushing me. You are pushing me beyond. I will ask for a recommendation for stripping of the senior gown, Mr. Rai. Please do not push me. I'm just telling you, please do not push me. Mr. Rai, please do not push me.
Kindly, what I said.
That's it.
He also, if you upload them. I can-
Mr. Rai, orders are uploaded. You know it.
My lord, you also-
Mr. Rai,
Going to Hyderabad.
Mr. Rai, you're going to Hyderabad. Cannot influence this court.
No, I not.
All right?
I not said this. I said, my lord, so if you get it.
Orders passed by this court always gets uploaded, Mr.
Sorry, man, sorry. I know you lost it. But I just say, my lord, and then I have.
These kind of submissions from a senior advocate,
No, what I'm saying, my lord,
And that kind of matter-
anxiety of my.
your anxiety is for what?
If I get the order, my lord, then I can advise them. This is my argument.
Mr. Rai, please
Yes, my lord, kindly.
stop it.
Kindly excuse me. Kindly excuse me.
No, senior advocate. What is going on?
My lord, you also absolutely correct, but I'm saying, I should not do something.
You get so
I'm not
perplexed
said
and
anything.
perturbed by a dismissal order
I've not said anything.
that you will go beyond.
No, I can't go.
Then,
I-
Mr. Rai, what is this? You are officer of the court.
But you're.
Mr.
I know
Rai,
it, my lord. I know it, my lord.
must have, you have put in 34 years. How many years?
35 more.
Mr. Rai, officer of the court, what are you doing?
Kindly, my lord. I'm not saying, I said, okay,
Please,
Kindly,
stop it.
kindly, kindly, my lord, don't, my lord, what I said, you also right to dismiss, I said, well, get the order, I advise. No, man, don't.
So you will get the order,
Don't
Mr.
take
Rai.
it. Don't take the orders. Sorry, man. I'm not saying this man. I'm not, and your lordship knows me, I know. I'm not there.
I didn't expect this from you.
No, sorry.
I'm actually,
I apologize.
honestly,
then I
Mr.
apologize.
Rai, I am shocked
I'm apologizing.
at your conduct,
I apologize.
at your behavior. I mean, if it would have come from somebody else,
I
I could have
apologize, my lord.
still taken
I
it.
apologize.
Mr. Rai,
I apologize, my lord. I say
After
apologize, my lord.
one
I
matter,
apologize, my lord.
dismissal can put you in this condition.
No, I'm not saying this.
You will make these kind of
You have
submissions.
the right to dismiss it, my lord. Yes.
I have heard you.
I said, I'll be the
I am
assistant.
passing an order.
No, sorry, man.
Then, Mr. Rai, you are doing this.
Man, I just asked the judgment. He said,
Sister.
sorry, man. Kindly excuse me, man.
So sad.
Kindly excuse me. No,
This bar, you're the leader of this
kindly excuse me.
Jalpaiguri
Kindly
circuit
excuse
bench.
me, please. Excuse me. Lordship, kindly don't miss.
We have designated you a senior.
Lordship, please, kindly excuse me. I'm not, this is not my.
And this is your
But I have to
conduct.
submit, man, not, but this is not the show cause notice. Listen, sorry, man. Sorry, man. Lordship, kindly excuse me. Please, man. Kindly.
I am absolutely.
Kindly excuse me, man.
I am shocked.
I
am really shocked.
I apologize, man. Then when
You appear in my court every day.
Man.
You see the court. You know.
You're always nice to me.
Mister, I'm today absolutely.
Kindly smile.
I'm disturbed with your conduct.
My madam, kindly smile, man.
I'm disturbed with your conduct, Mister.
Sorry,
I'm
man.
really disturbed with your conduct.
No.
If it was somebody else,
It's my fault. I wasn't trying to explain to Lordship, man. You know, here from the year he said, you know, the show goes on this. Sorry, man. This is the second time myself get it, then I.
you're passing an order.
Yes.
You're aggrieved by the order.
Yes.
You can
Can
take it
pass it,
nothing.
man. I'm not speaking. Can pass it. Please, please.
What is-
Please, man. Please. Please,
No,
man.
I have to, in a case of yours, I have to say this, that I'll pass the order in the chamber itself is such a demeaning thing to do.
Sorry, man. Sorry, man. Kindly pass it. I say, I keep silent. I not speak. You smile, then I go. Kindly.
I'm absolutely today, I'm really sad to see this
No,
conduct.
kindly, please. I'm not
This
speaking.
conduct from somebody, we are going to have, this is a young bar. You are going to be the leader of the bar.
I don't.
How many seniors are there from this bar? Only you? Only you.
Kindly,
We
please.
have designated only you because we find you to be the best leader in the bar and the most competent person.
Please.
And this is your conduct.
I'm sorry, but this is my miscommunication. I was trying to say what he said is not the show was notice. But man, sorry, man. This is just allow me. Also, I just trying
You
to.
will have many more matters.
Just kindly smile. Kindly smile. Kindly smile, man.
Not matters. Don't take it to your heart.
No, can you pass that man here? I'm not. Kindly, please.
Next.
Pass over, madam. Item number 5.
My lord, I am appearing on behalf of the Central School Service Commission, my lord.
Lordship, I am appearing on the petitioner, Lordship. This is the entity of service.
Yes.
My lord, pursuant to your lordship's direction, my lord, the learned
Yes,
advocate
Mr.
for the
Roy.
petitioner. Yes, my
Yes.
lord. My lord, I have taken instruction, my lord. My lord, petitioner was recommended by the Central School Service Commission by recommendation letter dated, my lord, 29th of January 2025.
That's right.
Subsequently, on 1st of March 2025, my lord, by issuing a letter, petitioner submitted his unwillingness to join the said recommended post.
That's correct, Mr. Roy. What are your instructions?
Yes, my lord. Subsequently, District Inspector of School and School Authority, my lord, forwarded this non-joining post to the Central School Service Commission for addition of the same post in the subsequent round of counseling.
Yes.
And my lord, pursuant to that, my lord, on 11th of June 2025, another candidate, Miss Piali Raha, was recommended, my lord.
Already recommended.
Already recommended, and my lord, law in this regard.
Yes. Yes, Mr. Roy.
Yes, my lord. Here, my lord, a recommendation letter shall be valid for a period of 90 days from the date of issue, my lord. She should have filed an application for extension of recommendation within the period of 90 days. Without doing so, she has submitted his unwillingness to join, my lord.
Yes. File your affidavit, Mr. Roy.
Yes, my lord. Yes, my lord.
No stay.
Lordship, may I submit?
Yes, my lord. I shall.
This is also, I'm only considering it on a sympathetic ground that your mother was suffering from cancer.
Lordship.
Otherwise, you yourself have given up your right.
Lordship. may I
And
submit?
even in terms of the guidelines which are there,
Lordship,
that is not applicable on you, sir.
what a moment, Lordship, you have.
Yes, sir, I have heard you.
Lordship, what?
You have argued this twice.
I have to add one or two lines.
Yes, please tell me.
Lordship. Absolutely correct, Lordship. The recommendation letter was issued on 29
29/1.
29/1/2025.
Yes.
It is also fact that on 1st of March, Lordship,
Yes.
I have sent one letter
Yes.
addressing to the Secretary of the Managing Committee, Headmaster, unwilling, dated 1/3/2025.
Sir, you have already.
Lordship, I am just reading out for Lordship.
Yes.
With reference number such and such stated above, I like to express my regret for inability to join the post of an assistant teacher in the upper primary level of your school as offered by first to 2016. Next paragraph, at present, next paragraph, Lordship, kindly come to page number 22, Lordship. For a moment, Lordship.
Much water has flown after that, sir.
At
Yes.
present, owing to unavoidable
This
circumstances.
is written by the school to the West Bengal, page 22, right?
Page 22.
Page 22, yes.
Page 22.
This is your letter,
This is
unwillingness.
the letter. So in the last paragraph, at present, owing to unavoidable circumstances relating to my mother's poor physical condition, I am unwilling to join the post at present, Lordship. Lordship, please.
At present, I am unable to join the post. You are reading at present.
At present, Lordship.
All right. So what are you trying to say?
And the next line, kindly read, my lord, the next line.
Let me complete.
However,
Learned Council, please let me complete. Next letter, Lordship, which has been correctly mentioned.
No, wait a minute. Mr. What is your name?
Mr. Shah.
Read the letter from first word to the last.
Lordship, same letter.
Yes, loudly.
Loudly. To the Secretary of the Managing Committee / Headmaster / TIC, Kebelpara Girls Junior High School, Prosanno Nagar, Rajganj District, Jalpaiguri. Subject, unwillingness to join the post of assistant teacher for upper primary level of class.
So read again the subject.
Subject, unwillingness to join the post of assistant teacher for upper primary level.
Now, what do you understand by that?
Lordship, this is true. But in the last paragraph, Lordship, I
Sir,
say
do we?
the reason has been assigned, Lordship, why I am not.
All right, read further.
At present, owing to unavoidable circumstances.
No, read with reference to.
With reference numbers stated above, I like to express my regret for my inability to join the post of an assistant teacher in the upper primary level of your school as offered by past 2016. Next paragraph, at present, owing to unavoidable circumstances of my mother's poor physical condition, I am unable to join the post. Next paragraph, which has not been mentioned by the Learned Council, that this letter was forwarded to the.
Sir, read the last line also.
However, I am grateful to the authority for offering me this opportunity.
So you have taken the opportunity, you have expressed your unwillingness, you have stated that you can't join because of your mother's.
But one more line, Lordship. The submission which has been advanced by the Council of the School Service Commission, Lordship, that this letter was subsequently forwarded to the West Bengal Central School Service Commission, Kolkata. Subject, this is the letter which I submitted before the headmaster. This letter was subsequently forwarded to the School Service Commission. Right. So when this letter was forwarded, kindly see, Lordship, page number 23, Lordship. On 9/4/20.
I'm saying that. I'm on page 23.
9/4/2025.
Yes.
On 11, on 29, on 29/1/2025, Lordship, I sent another letter which has not been mentioned by the Learned Council to willingness to join withdrawal of previously submitted unwilling leave letter. Page number 24, Lordship.
All right.
Lordship, kindly see.
I've seen that.
And this letter has been filed, which the Learned Council just now mentioned that this was not done within the stipulated period. That is 90 days. But this letter was submitted within the stipulated, within the 90 days.
Sir, the condition which he is saying is not even applicable for extension. He is saying that you should have sought the extension, which you could have done in terms of the guideline which you had shown me.
Rule 73, my lord.
It is not even applicable in your.
In the
Anyway, let them file their report.
The guidelines.
What?
So that, my lord,
Should I dismiss it?
Lordship, no, Lordship.
Should I dismiss it?
No, Lordship.
I'm just being sympathetic towards you.
Lordship.
Let them file their reply. That's the maximum I can do for you.
Lordship.
Lawyers don't even understand when the court is being benevolent.
Lordship. Lordship, I'm sorry, Lordship. I have learned.
You don't even have a right. You argue as if you are arguing your best case.
Lordship, I think paragraph of 17, Lordship. May I submit, Lordship?
Should I dismiss, sir?
No, Lordship. Lordship. Just I wanted to show the information, Lordship.
I've seen that. You have shown it to me.
Right?
Twice we have heard this matter.
Lordship.
This is the third time we are
Lordship,
hearing this matter.
as your Lordship, please, Lordship. As your Lordship, please. Lordship, as your Lordship.
I'll tell you each and every date and the content of all your letters. This is the third hearing.
Lordship. Absolutely.
And you are behaving as if we have not heard it. And we are passing an order without hearing you. Didn't we hear this matter 3 times?
Lordship, Lordship.
Then what is new?
I apologize, Lord.
The petitioner has preferred the present writ petition, being agreed by the inaction on part of the respondent in failing to respond to her representation dated 11/4/2025, 16/4/2025 and 29/4/2025, wherein she had expressed her willingness to join the post of assistant teacher upper primary school, upper primary level, full stop.
Level.
It is the case. Yes, Mr. Roy.
Yes, my lord.
It is the case of the petitioner that she successfully cleared the selection process conducted by the West Bengal School Service Commission for the post of assistant teacher, upper primary level, and was issued an offer of appointment dated 29/1/2025, full stop. However, at the relevant time, the petitioner's mother was suffering from stage 4 lung cancer, and the petitioner, being the sole caregiver, was unable to join the said post, full stop. Accordingly, the petitioner intimated the respondent of her temporary inability to join, by way of a letter dated 1/3/2025, full stop. Subsequently, upon her circumstances permitting, the petitioner, by letter dated 11/4/2025, which withdrew her earlier communication and conveyed her readiness to join the post, full stop. Thereafter, she sent reminder letters dated 16/4/2025 and 29/4/2025 to the respondents, full stop. However, the respondents no response has been received till date, full stop. Agreed by such inaction, the petitioner has preferred the present writ petition, full stop. Learned counsel for the respondent seeks and is granted 2 weeks, 4 weeks. How much time?
4 weeks, my lord. 4 weeks.
4 weeks will be too long. 2 weeks.
My lord, then kindly 3 weeks, my lord.
3 weeks time to
Yes, sir.
file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 4 weeks before the next available circuit bench.
Grateful, my lord.
More sympathetic than this.
Lordship, Lordship. Grateful, Lordship. Grateful.
Any other? Who will be ordered? All right, now you'll have a new building in the next time when I'm here, probably.
Lordship will be presiding over there.
Yes,
Lordship, have a safe journey from this side, Lordship.
thank you. Call the
For element, item number 1.
So I'm for the respondent number 3.
I'm remanding the matter back, Mr. Bosch.
Willard.
In the above, the impugn order passed by the learned tribunal is hereby set aside and the matter is remanded back to the learned tribunal for de novo adjudication, full stop. The tribunal shall consider the matter afresh after evaluating the pleadings appreciating the evidence on record, and shall allow the parties to adduce additional evidence if so required. The tribunal shall specifically determine whether the claimants are similarly situated to the workmen in Indian Bank Association Supra based on relevant facts such as the nature of engagement, degree of control exercised by the bank, and the other attendant circumstances. It is expected that the learned tribunal shall dispose of the matter expeditiously, preferably within a period of 4 months from the date of receipt of this order, in accordance with law and upon affording adequate opportunity of hearing to all the parties. The writ petition stands disposed of accordingly.
Grateful, extremely grateful.
It's all because of evidences.
That's very, very
Sketchy.
Very sketchy, absolutely.
Supplement.
Very sketchy and inadequate also.
Like a writ petition order.
Yes, yes. And in CGIT Millard, the pendency period is generally very, very long. So that observation will
That will
us.
help you.
Yes.
Because already they have been contesting.
Yes, yes,
for a
many
long-
years. We had to approach this honorable court earlier also to get a direction for expeditious disposal.
Today's well, there's a supplementary list. Yes.
My lord, I am for the petitioner, my lord.
Yes. Necessary correction be correct.
Yes, yes, my lord.
Three, four.
Chief.
Just give the details. All right.
Grateful.
Thank you. Had a nice, thank you.